Hello, everyone. My name is Allie Wilbur, and I'm the Executive Director of the Wisconsin Visual Artists, which is a 120-year-old artist nonprofit organization run by artists for artists. If you have any questions or interest in joining WVA, please go to the link below. I'm also happy to answer any questions that you have about the organization offline as well. Today, I'm very excited to have Elizabeth Russell of Russell Law with us. She's a wealth of knowledge. I'm very excited to hear everything she has to share with us today. She's a lawyer. I'm looking at my list right now to remember all this. A lawyer, an author, a speaker, a consultant, an art advocate, an educator, a photographer, and a musician. So a couple of things going on there. Today, she's going to share with us her kind of top 5 tips for creatives, copyright ownership, collaborations, commissions, agreements, image use, estate planning, kind of more of the common things that she finds in conversations with her creatives that she works with through Russell Law. I would like to extend a special thank you to WVA member Christine Stile for sponsoring this presentation. We hope to have more educational presentations for creatives like this in the future. Please, if you have any questions for Elizabeth, post them in the comments below. We will have a Q&A at the end of her presentation, and we will address all of your questions and concerns, and also tell you how to contact her offline as well if you would like to have a personal one-on-one discussion about your creative practice. So I'm going to let Elizabeth take over and share her knowledge with us today.
Thanks, Ellie, and hi, everyone. I am going to share my screen. What does that look like now, Ellie? Are we looking at just the screen? Okay, let's do it this way. Great. Well, so hi, everybody. I'm really happy to be here. Allie was mentioning that perhaps I've spoken to your group once before, and let's just say that I have, and happy to be back. So in the law world, as you can imagine, really any single issue could be a 3-credit class. So my challenge is to be useful in about 47 minutes. It's not a small challenge. This 5 tips format honestly is completely new for me. I've never done it before, so let's just see how it works. So my first tip involves copyright ownership, and you might be thinking, wow, how can that be a problem? The rule is so simple. If I created the work, I own the copyright, right? And yes, you are right. That rule is pretty clear. But in my practice, I have seen that applying that rule can be surprisingly complicated, especially when other people or other people's work are involved in what you're doing. I see this most often when clients want to register their work with the U.S. Copyright Office. In fact, I mean, you might be surprised at this, but I'm really not exaggerating that about 90% of the time, before I can help a client work on an application for registration, we have to go back and clean up ownership issues. So again, if I could hear you in person, I'd almost like be hearing you say, seriously? I mean, it's just me and it's just my work. Also true, I'm sure, for a lot of you. But visual artists have ownership issues in a lot of contexts, such as when you're working on your website, when you've used studio assistants, when you've used photographers, when you've worked with collaborators, when galleries create materials, when you're working on books about your art. It also comes up, of course, when your work includes material that's original to somebody else. But in all of those situations, there are elements of the work that are not original to you, that you as the artist did not solely create. And every single one of those elements has to be accounted for, and copyright either legally transferred to the artist or licensed and disclaimed in the copyright application before the artist can effectively register with the Copyright Office. So this, of course, gets me going on another minefield, which is do-it-yourself legal work. I agree that anyone can pretty easily prepare and submit a copyright application on their own, but without this thorough ownership analysis having occurred first, the do-it-yourselfer is very likely to make misstatements and errors of omission, which means they will get a registration. They'll get a registration in their hand. But when the time comes to rely on it, they're going to be disappointed because those errors are going to invalidate the registration. And that's a crappy surprise to encounter. Commissions, I heard from Allie that you were talking about commissions in your last session. Commissions are another scenario where copyright ownership comes up, though for artists kind of in a reverse situation. I would say 9 times out of 10, your commissioning party will assume that they own the copyright because they paid you to create the work. And when they find out that they don't, things can get unpleasant. And unfortunately, that's what I see because that's the only time I ever hear about it. And if those things go really bad, you can easily spend way more money extricating yourself from the situation than you would have in the first place if you had just used a well-drafted commissioning agreement. My final example on copyright ownership is you doing business as or through a legal entity like an LLC or a corporation. Our simple ownership rule that we just talked about doesn't change just because you chose to create a business entity. You personally are still the owner of the work you create. So you have to think of your entity as a completely separate person. So think of it as a separate person, like with a person's name, like Dave. Your friend Dave doesn't own copyright to your work, and neither does your business entity, even if you are its only owner. So there's no way around this, okay? If you formed an entity for your art business, you do need one or the other of these things. Either licensing and agency agreements in place between you and Dave, so Dave can make deals for you and use your work, or an assignment of copyright from you to Dave so that Dave does actually own the copyright to the work. And way too often, I see copyright registrations that an artist did on their own, listing their business entity as the copyright owner, but none of this underlying work had been done. So again, the registration issued, but now when the artist needs to rely on it, it's ineffective. And again, that I won't use bad words, but that is very unfortunate. Okay, so tip number 2. The next tip is to be super careful with stock and royalty-free images. Royalty-free means you don't have to pay money. It does not mean there are no licensing restrictions. Somebody does own the copyright to every single image or video or piece of music that you download from a stock site. And by downloading that work, you are almost always agreeing to a lengthy legalese licensing agreement. It might take some digging, but I can almost guarantee that there will be a licensing agreement attached to every work you download. So you have to find that agreement. And yet you have to read every single word of it, because if you use the work in some manner that the agreement does not permit or expressly prohibits, you're on the hook, not only for copyright infringement, but also for breach of contract. And you might be on the hook someplace other than Wisconsin or even the United States. For example, if you violate this FreePic license, you're going to court in Spain. As you can see here, even Creative Commons licenses have a traditional legalese license agreement. What we're looking at here is what most people assume is all there is for Creative Commons. But look what I circled there, view legal code. When you view the legal code, this is what it is. And this is just a tiny snip from the actual lengthy license. So here I go back, you click on view legal code, and you get this, and you'll see it. Be sure that you do that every single time and read the entire thing. And in case you're wondering, yes, people do get sued for violating Creative Commons license provisions. So if you have to use stock material, just be sure to find the entire license agreement and read every word. I know, I can see you laughing almost in my mind. So if you don't feel like doing that, or if you are laughing hilariously at that suggestion, stick to only using material you created yourself, or use material that you have licensed directly from the copyright owner for your exact needs. Number 3, the next point involves myth. In particular, those surrounding our use of people's names and images. Allie mentioned that I'm also a photographer, and as a photographer, I tend to focus on people. Sometimes I ask their permission, most times I don't. So as both a photographer and a lawyer, I am often asked, can you do that? I can only ever answer that question in connection with a single specific photograph, and then only in connection with exactly how I am using it. When it comes to depicting a person's image or using their name or alluding to their identity, the legal analysis depends on 2 really important things. First, exactly what you are doing with the image or the identity, and also what state or jurisdiction's laws govern your actions. So if you ever ask that question, like, can you do that? If anyone ever offers you a black and white yes or no answer, ignore it. And here's why. Here's why is like, look at what, finally, I will explain what you're looking at. So in connection with one scenario, let's say, our analysis might end up with one conclusion. Let's say that conclusion is solid figure, both arms extended. Right? And let's say that that is the correct answer in that particular case on those specific facts. But the next time something similar comes up, the facts are going to be different. That's a given. The facts are always going to be different. So the next time the answer might be transparent figure, both arms extended. And the next time the answer is one hand on hip. The next time it's both hands on hips. They're similar, but they're always a little bit different. So you can't tell anybody that the answer is always going to be solid figure, both arms extended in all situations. This is how myths start. And all right, don't take offense, but if you're the one spreading the myth, you are the legal equivalent of an asymptomatic carrier. So don't be that person. All right. Here's some examples. In this photo, one person is famous and the other one is not. In many states, that makes a difference depending on what you're actually doing with the photo. Also in this photo, at least one person is now deceased. That too changes the entire analysis, and it makes a huge difference. It makes a huge difference what state you're in, because in some states, the right of publicity survives death, and in others, it doesn't. Now, one thing to keep in mind is that none of this has anything to do with copyright. People's rights of privacy and publicity, which is what I've been talking about, are completely separate areas of law. So while you might be fine, you might be totally fine copyright-wise for using a particular work, you have to do a completely separate analysis under privacy and publicity laws if the work depicts people. So again, there's a lot to that, and you're probably like, so how do I do that? And that's for another day, because that's not something we can do in our short amount of time. My goal is that these are going to help you recognize issues when they come up and do what you have to get answers before you act on myths or on not recognizing a situation. One more example. Here's a non-famous person looking at a photo of Betty Ford, who is, of course, famous and also dead. So here we've got copyright issues with the photo of Betty Ford. We have copyright issues with see that photo in the background there of other people? That's also somebody's copyright. And we have copyright issues with the text that's written there in the exhibit. We have to look at privacy and publicity laws, though, separately for Betty Ford and for the non-famous people who are also depicted in this photo. And that analysis will completely depend on what we are doing with this photo. Not that it exists, not that it was made in the first place. And that's a common area. The fact of making the photo in the first place is not the issue. It might be in some other countries, but here that's not the issue. It's what we do with it, not the fact that we created it or that it existed. All right, next tip. I'm going to be honest here. This is a perpetual problem in my practice. And I'll tell you right now, I do not have a solution, but it's important that we talk about it. So here's how it usually goes down. The artist has some kind of opportunity and is being asked to sign a contract. The artist brings the contract to me and says, how much is it going to cost for you to just take a look? I, of course, have no idea because every contract is way different. So what I say to make the artist feel comfortable, and this is like, I've found that this is a good way to start out, is I'll just say, okay, how about I take no more than 1 hour, right? And then after that, we'll have a better idea about what we're dealing with, and we can make a plan together about what we're going to do for next steps. Usually the artist says, okay, good, I'm comfortable with that. They say, fine. So I take that look. Contract is terrible, right? It's really, really bad. And honestly and unfortunately, this is almost always the case, even from like really well-regarded companies that are offering opportunities for artists. Their contracts are, I don't want to say laughingly because it's not funny, but they are bad. And it continually astounds me that this is the case from otherwise professional companies, because honestly, it looks really unprofessional, both for the company and for the artist, to use a bad contract. But anyway, the reality is this is almost always the case. The contract's terrible, right? Somebody had just cobbled together random crap from the internet and told the artist to sign. So obviously this is a bad situation. So what do? Well, here are all of the options, none of them good. Here's option number 1. The artist pays me to redraft the contract so it's legally sound and reasonable for both parties. The artist had no intention of making that kind of financial investment, and now if they don't know me, they think I'm just trying to pad my bill for doing this, which is not at all the case. But as a lawyer, and you should know this about all lawyers, once we start working with a client, we owe the client a duty of competence and a whole bunch of other duties. So we can't ethically let you sign a terrible contract, right? We have to suggest these alternatives. And you're like, wow, I did not plan on that. All right, so here, what's another option? The other option is I just make a list of all the problems, and then we send it back to the company or the other side and ask them to make changes and redraft. This too takes probably more of my time than the artist had in mind, but less than me doing the actual work. And it only works. This is the other problem with it. It only works if the other side is both willing and competent to make those changes. Having both of those things is a rare combo, but that's what it takes. Sometimes it works out, usually it doesn't. So now what? If neither of those is an option, the artist has to either pass on the deal, and unfortunately that happened. Well, I say unfortunately, but sometimes that's a good thing because it would have been a bad deal, and this process kind of winnows that out. So either the artist passes on the deal, or this happens a lot too, the artist fires me, and honestly, not in a bad way, we agree on this. The artist fires me, does their own redrafting, signs the bad contract, and then just hopes that something terrible doesn't happen. And if you've ever done your own plumbing, you kind of know where this is going. But realistically, there are going to be times, right, when the potential of a deal merits investment in legal counsel, and there will be other times when it doesn't. So you, as the artist, you have to decide which situation you happen to be in. I'm offering these ideas as a starting point for your decision-making process when that comes up. Honestly, a lawyer's guidance would also be helpful in coming up with answers to these questions. But I would start here and think these things through as you're deciding, am I going to the lawyer? Am I not going to the lawyer? And if I do go, am I prepared for the costs of doing this correctly? Because it's going to be more than I thought. So if you do go it alone, and I know that will happen on occasion, here's my tip. A lot of times the danger isn't so much what the contract says, but what it does not say. The absence of certain provisions can defeat an entire contract, or this is a corollary, it might be like not a terrible contract at all, but it might be exactly the wrong kind for the deal that's going on. I had a client once show me very proudly that he had found a joint authorship contract on the internet. And I looked at it, and honestly, it wasn't that bad. The problem was a joint authorship situation was the exact opposite of what he really needed. And if he had used it and executed that contract, it would have 100% defeated his intent, and he would have actually lost a lot of copyright rights. So it's the danger. I know everybody can read, and you can look up words, and you can see what there is in front of you. What you can't see is what's not there. Or, as I said, you might be looking at what's not appropriate for the situation. So basically, either, this is my suggestion to you, either invest in doing, if the situation and the deal merits this, invest in doing contracting properly, or be willing to lose everything if it goes bad, or pass on the deal. I know those are hard decisions to make, but I don't have anything other than to say those are the choices. So I encourage you to look at them honestly, and though difficult, choose the one that applies to the situation. Final tip. I went pretty fast, so we'll probably have some good time to go back for questions and to flesh out some of these things. The final tip is copyright in estate planning. Copyright needs to be handled differently than all of your other assets in your estate planning documents. So here it is, kind of in a nutshell, the concepts. When you look at standard will language, standard language that lawyers put in wills, it almost always mentions tangible personal property. But very infrequently do you see it specifically mention intangible personal property. And that's what copyright is. Copyright and other types of intellectual property are intangible personal property. It's a completely separate type of asset than tangible personal property. So if the will mentions tangible personal property and there's no other specific mention of copyright anywhere in that will, the result is that the copyrights are going to pass with what they call the residue of the estate. And that basically means the dregs and leftover assets that weren't given much thought or any thought. And often the residue of somebody's estate goes to a beneficiary that's really low on the priority list, like, a distant relative or a charity or somebody you really hadn't even thought much of. So the consequence, this is the dangerous consequence of all this, is that an artist's valuable copyright rights could easily pass to an unintended beneficiary if this issue isn't given proper attention. Now, most estate planning lawyers are really good at what they do. By and large, they're great at what they do, but for some reason, they don't know this. I'm not sure why that is, but they don't. They think we've got it, and they really don't got it. Because there's another thing too, because copyrights should never be transferred into lifetime trusts, because that triggers something called the copyright termination right, which can seriously mess up an artist's estate plan. Again, though, estate planning lawyers are typically not hip to this. And every day they transfer like all of a client's assets in a big lump, including the copyrights, into lifetime trusts. That's an error. It's much better to exclude copyright from lifetime trusts and have copyrights pass under one's will, with specifically drafted copyright language in the will, to make sure that the copyrights end up passing to where the artist intends. So that's the sort of troubling situation. The good news is I wrote a whole book about this just for the estate planning lawyers, and they won't know to go look at it, but you can know this. So when you're working with them, you can buy this as a present for your estate planning lawyers, and you might actually enjoy reading it yourself. It's all in a conversational format, pretty easy to understand. But honestly, I really wish every estate planning lawyer would take a look at it when they're dealing with creative people where copyright is an asset of the estate. So those are my 5 tips. And I wanted to leave plenty of time to talk about your specific questions. I'll say in advance, if your questions are easily answerable, I'm all for it. If you're raising something that actually does require a 3-credit class, I might have to pass. So don't take offense at that. But Allie, I think we're ready to go to the questions.
All right. Well, great presentation. You packed a lot of information in 27 minutes. Impressive. We do have one question posted so far, and everyone else watching, I'm sure you have a million questions swimming in your brain. So type them into the comment section so that we can get Elizabeth's answers while we have her here with us. We have a question from one of our WVA chapter chairs, Stephen. What types of situations are contracts required? Or what would you say is like necessary for a certain project that you have a contract between 2 parties?
That's a great question. And I'm going to back it up a little bit and talk about what a contract is. The reality is, what I think I hear the question being is, when do we need a written contract? The reality is that behavior can form enforceable contracts. A contract legally has 3 elements. Somebody makes an offer, somebody accepts that offer, and there's an exchange of some kind of obligations. If that happens, you have a binding contract. For example, one of the part of your question is, when do I think it's necessary? Commissions are a great example. There's so many issues that need to be clarified in that scenario. So we could use that as an example. Let's say there's no written commissioning agreement, but we have an offer, like Mr. Jones says to the artist, I would like you to paint my portrait. I would like to commission that. And artist says, okay, I will do that. So we have an offer, we have an acceptance, and each side has to give something and get something. So Mr. Jones says, all right, I will pay you $5. And artist says, okay, I will paint the portrait. Done. That's a contract. You've got it just by having that conversation. There are certain types of contracts that do have to be in writing because the law says so, and that is in states there's usually a dollar amount threshold where if what's at stake is over a certain amount, then the contract to be enforceable has to be in writing. There's other kinds of contracts like real estate and wills and stuff, they have to be in writing. But basically, I would, again, reformat the question as when is a written contract required? Because anytime you're agreeing to do anything, you are potentially and usually, in fact, creating a binding contract. So this is sort of a cautionary tale about be careful what you agree to, because whether it's in writing or not, a lot of times it will be enforceable, and you need to be mindful of what you've agreed to do. So in terms of the situation, so obviously my answer is it's way better to have things in writing, like whenever you possibly can. As long as it's done correctly. If it's I'm gonna clarify that, because if the contract has been drafted correctly and it's appropriate for the circumstances, then yes, I think it's better to have the written contract. If it's a crappy one from the internet or it's the wrong one, honestly, my view is you're better off without it than potentially having the minefield of what you might find from the bad contract.
You did mention that you've seen a lot of bad contracts. Is there anything that comes to your mind right away of like, what are the main things that are missing from these contracts that artists should be making sure to include to protect themselves beyond, this is when the project is expected to be finished, this is what we're expecting to be paid, are materials included, things like that? Like, what else is usually not included in these agreements?
Well, one thing often is a transfer of an assignment of copyright ownership. If that is part of the deal, that has to be addressed the law says it has to be in writing and signed. And if that doesn't use proper assignment language or it doesn't appear at all in the contract, the copyright ownership is not going to transfer. And a lot of times that'll be the case when between designers and their clients, and they'll assume that the copyright transferred to the client, and it doesn't if it hasn't been done right. I can tell you that another pitfall that people often overlook in a lengthier contract, like from a company, is the section called choice of law. And they just glance over it. It'll say this contract is governed by the law of Alabama or whatever, and they're like, all right, I don't care. That can be a huge pitfall. An example I often use is California. And I had a client who was a recording artist and got a record deal in California, and who was from here. And the contract said it's governed by the law of the state of California. And he's like, okay, fine, what do I care? Well, as it turns out, the state of California has a law that I won't go into all of the details, but it operated drastically to the client's detriment. Without the contract didn't say that. All it said was it was governed by the California law. But as it turns out, California had a law that said a record company can sue a recording artist if they don't deliver their albums within 7 years. And like, the client would never have known that. But you needed a California lawyer to explain it. So if you gloss over these things, you honestly really just don't know what you're potentially getting into.
Dang, yeah, okay. That's a great example.
Another thing to look for is definitions. A word in a contract has the meaning that the contract gives to it. And the way that you identify is that words with specific definitions are capitalized. So if you come across a capitalized word in a contract, first thing you do is like stop reading and go find where that definition is, because you could see the word, paintbrush in a contract, and if it's capitalized, paintbrush could be defined as lampshade, and for that reason it would mean lampshade in that contract. So that's definitely something to look for, is how capitalized words are defined.
I do have another question here from Michelle Lewis. Can you give us 3 simple things based on your experience that we as visual artists can usually do ourselves without an attorney, but that we should not do ourselves? Or is it mostly a what's at stake issue?
It's a lot of what's at stake issue. I think what you can do is start out by, especially in contracts, by doing that analysis that I suggested, like what's at stake here? Is it, think about what's going wrong. I mean, that's what we do as lawyers, and we're razzed for it all the time. Like, why do you always, think about what's going wrong? I mean, like, but that's our job. That's what we're supposed to help protect you against. And no, it's not every tiny little thing, because things go wrong and sometimes they're not even consequential. You have to decide for yourself what is acceptable and what's not for when things go wrong. And so that's the place to start. You have a contract come in from a company. Assume everything goes wrong. What's the worst that's going to happen to you? Is it going to be your work is going to be used out there without attribution? Is it going to mean somebody else is going to be selling your work and you're not going to be compensated? Is it worse than that? One thing to consider is somebody going to use your work in a way that some third party might end up suing you? That would be really bad. But I don't know. I don't know the answer for that. Only you do in your own business. So that's the first thing I think that you do on your own. In terms of copyright registration applications, I don't want to be heard as saying you can never do that yourself. You can. I would suggest that you start out with counsel and come up with a template for what you usually do, and make sure that together we've kind of navigated the potential pitfalls. And if you're making the same kind of work over and over again, yes, you can start using that template. That is one thing that you can start doing yourself. Again, though, I would recommend that you not just that you get advice up front before starting to do that. So that's 2, and of course Michelle is requiring 3 things that you can do on your own. So let me just keep thinking, and I'll come up with another third one later.
Okay. Kind of actually on the point of copyright, something that I see artists do a lot, and I don't know that it's quite necessary, but maybe you have a thought on this: watermarking. Watermarking images of their artwork for social media, for their website. Is that necessary? Is it helpful? Does putting the copyright symbol on a picture do anything at all?
Sure. Those are technical measures that certainly don't do any harm, and they can be beneficial. Let's start with the notice. Putting the copyright notice used to be required, or you didn't qualify for copyright protection at all. That's not the case anymore, but it is very useful for 2 reasons. One, just practical reason, is it puts the public on notice. And if somebody infringes a work, there is a provision in the law where if they get sued for that behavior, they can reduce the amount of damages that are against them by claiming innocent infringement, like I didn't know. If the notice was on the work, they can't do that. So innocent infringement is no longer an option, and the full measure of damages will be available. So it's a good reason to put the notice on the work whenever you can. I'll take this opportunity to talk about the notice, though, and something that is another kind of misunderstanding, and that's the year in the notice. So the note I can't like write in front of you, but the usual notice is the word copyright. I don't know why I'm showing you my fingers. That's not helpful. The word, the word copyright, then the C in the circle. And then a lot of times you see the date, and then you see the name of the copyright owner. The date is what I'm getting at here. That's a lot of misunderstood. A lot of people just slap on the date of whatever today's date is and think that that's what you're supposed to do. It's not, and doing that is dangerous because the date has a very specific legal meaning, and that is the date that the work was first published. Now, publication has a specific legal meaning. That publication in copyright law means the date that you took a tangible physical copy of the work that somebody could hold in their hands, including a file, and you made that tangible copy available to the public. Like it changed hands from you, the artist, to the public. That's what publication means. If that hasn't happened, the work is not published. So if it's just appeared on your website, if it's just been performed or just displayed, but you didn't make tangible copies available or offer them for sale to the public, there is no publication. Now, the reason this matters, it goes back to damages. Again, if you're in a dispute and you need to take action against an infringer, whether the work has been published or unpublished severely affects your rights. So you don't want to just slap that date on there because that's an admission that the work has been published. And if your work is unpublished, you might want to keep it that way to preserve your rights in the future. So do think twice about just slapping that date on there. And again, get some advice. And once all right, this is issue number 3, Michelle Lewis. If you get some advice up front, and once you understand the concept, then you can determine whether your work is published, use the date, or unpublished, don't use the date. Oh, and watermark. Go ahead. It doesn't really have any legal implications. I know it has some aesthetic implications. That's really the difference between taking technical measures, which can help you create evidence if you need it moving forward. It doesn't affect your rights, but it can affect your ability to succeed in a dispute by creating evidence. Sure.
Gotcha. Okay, great answer. So you offer a lot of things through your practice. You talked about having like a standard 30-minute consultation with artists or creatives that have questions or anything. You teach classes at the college level. Can you just kind of outline what your offerings are and who should be reaching out to you and what for? Like what would an artist be able to work with you on if they contacted you?
I'm inclined to dodge that question because the answers are all on my website, and I actually want to. They literally are. If a person goes to my website, they're going to see exactly what I do, and I can say to you that I instituted the 30-minute consultation procedure several years ago, and I'm really glad I did because a lot of times people, that's all they need, really. For, again, this is ethical reasons, not financial reasons. A lawyer can't talk to you about the merits of your case or in any way start giving legal advice without all these duties kicking in. And it's not good for either side, the lawyer or the client, because I can't deliver on those duties if you just stop me on the street and say, "Hey, I've got a quick question." I was like, "No, I'm not answering that because all these duties are kicking in." But with the flat fee 30-minute consultation, I can give enough consideration to be responsible and to outline the boundaries of what our relationship is, and then the artist can walk away with actual usable information which is way better than me saying, "Yeah, no, I'm not going to answer that." So that has proven to be pretty useful. Other than that, yeah, you can pretty much tell everything I do by looking at my website. So I'm going to answer a completely different question, which is, what is the copyright termination right that I was referring to in estate planning? And this is something, if you transfer copyright rights, even in a license, during your life. Now that's why I was harping on don't put it in a living trust. Any transfer of copyright rights that happens during life triggers this thing called the termination right. And what that means is that between 35 and 40 years after that transfer, whatever that transfer was can be terminated. Like, suppose you made a deal with a publisher for your art to be, on I don't know, motel room walls or something, right? You make that deal today, and you necessarily either licensed or transferred the copyright to that work. That's the transfer happened today. 35 years from now, you say, I don't like, that was a bad deal. I don't want that to be the case. I'm going to stop that transfer, and you get back all the rights that you transferred. And if it's you, the artist, who's alive at that time, fine, no harm, no foul. You can just get your copyright back, which is cool. But if you're not alive at that time, the law specifies who gets to terminate that and get all the copyright rights. And it's not the people that you maybe said in your will or your trust. It's who the law says, and they might be people that you really, really don't like. So those people at that point in time end up with your copyright rights, as opposed to the people you actually would have preferred. So that can, as I said, can really mess up a person's estate. And that is a conversation that I strongly encourage all copyright owners to have with their estate planning lawyers.
Does that include just having a date that the contract extends until in the contract?
It doesn't matter when how long the contract lasts. The concept is that you made the transfer today, and then the 35, it's more complicated than this, but for our purposes, the 35 years starts ticking today. And when that window opens, 35 years, there's a 5-year window where the grant that you made today can be terminated, and you get the contract back. You get the rights back.
So much.
There is, but it's, it's very, that can be super lucrative. Maybe not for all of us, but for some, it's a big deal. I mean, if you Google copyright termination right, you're going to see lists of cases where there's, the estates of prolific artists in all, not just visual artists, but musicians and writers. Steinbeck's one of them. Their families are engaged in significant litigation over this issue. And it all could have been avoided if their estate documents had handled it properly. But it's also a cool thing to know that, if you made a deal and you're like, oh, why did I do that? There is a way to get out of it. You just have to wait 35 years.
Okay. Any other final questions for Elizabeth before we log off today? We have a bravo. Thank you. Very interesting talk. The tip of an iceberg, I'm sure. Okay. Those are the main questions that I had. Thank you so much for talking with us today and sharing insight into this whole other aspect of being a professional creative that most of us don't think about and maybe should be thinking about, and not Googling quite.
Thank you. That's great. And not Googling.
Maybe that's something to take out of this today. Contact Elizabeth Russell. Don't rely so heavily on Google for your professional legal situations.
That might be my new tagline.
T-shirt. All right. Thank you so much. Again, I'll throw up her website. I put her website in the comments, ERK Law, to see everything that Elizabeth offers and to read more about her and to find her books, which are very approachable, well written, as I understand. And if you would like to learn about Wisconsin visual artists or join WVA so you can be more in the loop about programming that we offer and exhibition opportunities, this is the website, wisconsinvisualartists.org. Thank you all. Have a great Monday. Enjoy the beautiful weather.